Lays out on third reading and final passage House Bill 1399. The clerk will please read the bill.
HB 1399 by Smith, relating to the creation and storage of DNA records for a person arrested for a felony offense.
Chair recognizes Representative Smith to explain the bill.
Thank you so much. This is a chance for us to extend our abilities to catch really bad individuals. There is no discriminatory information that's going to be collected in this, as explained yesterday.
Speaker, will the gentleman yield for a question?
For what purposes does the gentleman yield for questions?
I will, yes.
Gentleman yields for question.
Mr. Smith, again, I want to ask you a question. If someone has been convicted of a felony, can a DNA sample be taken from them?
Yes.
They can. Any felony?
Not under my bill.
No, the question I'm asking is that already, can the state of Texas already take a DNA sample from you if you've been convicted of a felony?
Upon conviction, yes.
So your bill only applies to people that are innocent. Is that correct?
No. No, it doesn't.
There are two types of people. There are guilty people and there are innocent people, and the Constitution says you're innocent until proven guilty. So if you're allowing the government to take DNA evidence from you when they can already do it once you've been found guilty, doesn't this only apply to innocent people?
Yes, they are presumed to be innocent at this point, and they enjoy that presumption all the way to the end. There's no question about it. They also enjoy the right to a jury trial. They have the right to have a case proven beyond a reasonable doubt.
Again, the question I'm asking is why don't we do this to everybody?
Well, so what we're doing already, okay, provides upon indictment. Well, we've been doing this since 2005, Mr. Toth. We've been taking it on indictment. We also, since 2005, I believe, have been taking on arrest for felonies. If you have been previously convicted of one of those 24 or 25 that I've listed out, then we take it upon arrest. Okay? What I'm doing is expanding the database. It's naturally going to expand the database just a little bit. We're going to do it, instead of up on indictment, we're going to take those 24 and we're going to put it on arrest. And the thing to remember this, I don't know how many felonies we have in Texas. There's possession of controlled substance less than a gram. There's possession of controlled substance 1 to 4 grams. Unauthorized use of a motor vehicle. You can just go on and on and on. There's hundreds of felonies. I'm talking about taking the DNA from someone on arrest of 24 of those hundreds, and the numbers are murder. The ones I'm talking about are murder, capital murder, kidnapping, smuggling, trafficking, continuous sexual assault.
So if you've already been arrested for that crime, correct? You've already been arrested for that crime.
Yeah.
And there's DNA evidence already on the victim or with the victim or on a weapon, and you've been arrested for it, can the district attorney with probable cause ask for a DNA sample?
I believe
the answer is yes, correct?
I believe that's right. Yeah.
So, okay, so what your bill does, it doesn't lend anything to guilt or innocence of someone that is going to be found guilty, because the DA can already take a DNA sample from you, correct?
You know what it does?
What?
It exonerates them quicker.
No, it does not, because again, at the end of the day, the defense attorney can offer up DNA evidence. This is no probable cause, which the founding fathers believed that was imperative to have probable cause before you go and seek this out.
Again, we're doing this already, and we have been doing it since 2005. All we're doing is moving from indictment to so the indictment is way before a trial, right? And so what happens is the person gets indicted, and under current Texas law, we're taking their DNA once they get indicted, and all that requires is that a grand jury determine that the case should be moved forward.
So we heard several members yesterday that defended this legislation under the guise that for a woman that's been sexually assaulted, if that woman has been sexually assaulted, someone has been arrested, and there's probable cause, can the DA already get a DNA sample?
I believe he can, yes, later on. But
What's that?
Yes, later on in the process.
Not later on in the process. If you've been arrested and there's probable cause, the DA can ask for DNA evidence.
Here's the other thing to remember about this, Mr. Toth, is under my bill, these 25 charges that I'm talking about, out of the hundreds that we have in Texas as felonies, most of these crimes do not occur in the sight of a law enforcement officer. So what happens is these guys end up being arrested as a result of a probable cause warrant, okay? So that you're not talking about just someone getting snatched off the street. We're talking about an investigation's been going on typically for weeks. There's enough probable cause for an elected district judge to sign a warrant.
Then that's not what your bill does. That's not what your bill does. Though.
No, that's exactly what happens.
It is not what your bill does, though. Your bill doesn't seek probable cause for evidence. If there's probable cause already, they can take a DNA sample.
Because, Mr. Toth, if you get arrested, in order to be legally arrested, there has to be probable cause.
There's probable cause for the crime.
There has to be probable cause already in order for there to be a good arrest. And guess what? If there's not a good arrest, then what happens there is a defense lawyer is charged with filing a motion to suppress.
So the problem, though, is
arrest.
that it may not even be a sexual assault. But what you're trying to do here is say that we're just going to create a big dragnet for people across the state of Texas. This is the very thing that the founding fathers warned us about.
It's not just sexual assault. If you
You're
look
right.
at the
It's
list,
not just sexual assault. It's all sorts of things that your bill enables them to take a DNA swab for.
yeah, like capital murder. I just think that we need to be able to resolve crimes against capital murders. We also need to exonerate those who are wrongfully accused. The thing about this stuff is it's accurate.
Reggie, I think you're a great guy, and I just wish this wasn't your first bill, brother. I think the world of you. I think you're a good man. But
you,
just consider something a second. And watch out anytime the federal government comes and uses words like the Patriot Act and says that this is truly about keeping us all safe, and then we find out that the federal government is surveilling Americans when they said that they'd never do it. They said they'd never do it, and yet they're doing it all the time. The state of Texas said, we only want one digit, one fingerprint, one marker for your driver's license. Then we leave session in the 83rd session, and all of a sudden, they tell people in the state of Texas that they want all 10 digits. This is creeping government, buddy, and this is bad. This is a bad bill. I love you, respect you, but it's a bad bill.
And you know I love you too, man. Thank you.
Thanks, buddy.
Thank you.